what do you got?
I think I can prove to a judge that both of these men had the mens rea.
What the hell is a mens rea?
It's a legal term the lawyers use. It just means the intention to commit a crime.
Okay, come on, let's go.
Mens rea?
Put the cuffs on him.
How could we have gotten mens rea? We take blood? Can you do it without taking blood? We both use condoms. How is this possible? I want to see a doctor. Can I have an independent blood test?
Money!
I feel sick.
What are you doing?
Mens rea! Oh! Oh! My God! No!
Hey, everybody. Good morning, good afternoon, good evening, good night, wherever you are, whatever you're doing. I'm glad to see you here. It is a wonderful Wednesday evening here in dark and cold South Korea. How is it where you are? Today, we got a little something different. We got something a little bit special. We're going to be talking about internet legend, assistant public defender out of Florida, an amazing top tier, one of the best you'll find in the entire United States, Steve Gosney. We're going to be doing a little Steve Gosney in this little thing we're calling Steve Gosney Out for Justice. So what's going to be happening tonight? We're going to be looking at one of Steve's cases. I've talked to him. All of this is cool. He's cool with us doing this. He's not going to be here. He's not going to participate in the discussion. He may be lurking. We just don't know. He might be lurking and watching and seeing what we're saying, but he's not going to be a guest here. That would be really weird and awkward. But he worked on a very, very special case over the past couple of years. And some very, very interesting issues were raised. As I mentioned, if you actually read the video description, a guy is convicted. He appeals the conviction. Was the conviction unjust? What happened and how did it all turn out? That's what we're going to be talking about. That's exactly. It's better if Steve ain't here. I'll be less shy to comment. I hold back, guys. Now, see, this is the thing. I got a hair. It's like when my hair is curling up my nose, it's tickling me. That's the thing. Talking with Steve, he said, if everybody wants to continue this discussion and we want to discuss some of the issues with him or discuss this case with him, he would be willing to come back at a later date, probably next week, to talk more about this with us if you want it. If the chat wants it, he said. He said it's up to the chat. So that's why we have the poll. Today's like and subscribe poll deals with that. If you go and hit the like button, hit the subscribe button. Again, we're doing this thing. YouTube is on this kick now where you gain 10, 15 subscribers, then you lose 10, 15 subscribers overnight. Then you get 10 or 15 more subscribers in the daytime. You lose 10 or 15 overnight. It's doing this YouTube roller coaster they're on. So please hit that like and subscribe button. And if you have already subscribed, get down there, click, make sure you're still subscribed. That's it. So take the like and subscribe poll. And how you do that, you hit the like button first, then you check to make sure you're subscribed. And if you're not, you do. If you were and you're not anymore, do it again, and then come and take the poll. Today's poll is hit the like and subscribe button to let Gosney know we want him on. Hit the like and subscribe button to let Gosney know he rocks, to help Gosney find his K-bar knife, and to prove Steve did it. Of course, the last two are joke entries. We want to focus on the top one. Let Gosney know we want him on, because it would be great to have him on here and talk about this in greater depth and set the record straight for all of the crap I'm going to get wrong while we go through this tonight. But I found this case particularly fascinating for for three reasons. Let's see if I can get them out of my mouth before I remember them. One is it raises some very important questions about police work and prosecution. It is a very interesting case. And three, you get to do something tonight that is very rarely seen. You get to see an actual appellate court argument. It's unlike most things you've ever seen, and probably unlike anything you've ever seen in court-related videos anywhere. And we'll talk about that in a little bit later. But those are the three issues that are really, really fascinating here. And I think it'd be great to have Steve come back on at a later point, and we can talk more about this. And you can raise the questions for him that you won't get answered by me today. So while we're doing that, again, make sure you hit the like and subscribe button, take the poll. Super chats, as always, not required, not part of the deal. There's no minimum chat to talk to me. We do what we can. I try to address as many of the comments as possible. We can't get to them all, but we get to the ones that I noticed, the ones that are particularly interesting, the ones that are relevant, et cetera, et cetera. But if you do super chat, if you do part with any amount of your hard-earned money to support me and the channel, then you're guaranteed to get your super chat read, addressed, questions answered, etc. And Bad Weather Biker started it off. The Schabusiness bailiff got out in better shape than the last male she had a struggle with. Yeah, those of you that watched last night saw our Taylor Schabusiness update. I was all excited about this because there was a trial going on just as the show closed out, and I was going to come back with the update on how everything was cool and we're going to trial. That didn't happen. She attacked her lawyer. After he was granted the extension that I didn't think he was going to get. He got the extension. I didn't think he was going to get it, but as soon as the suspension was announced, the extension was given a 2-week extension. She attacks her lawyer in court, and I've got comments about that. We don't have time to address it tonight. We might get to it before OJ on Thursday. Tomorrow. If not, we'll do it on Friday. We'll show you the video from a couple different angles. It was caught on a couple separate courtroom cameras. If you haven't seen it, we'll go over it, and I'll give you my thoughts and comments on that particular incident. But the Schabusiness trial has been delayed until at least May 15th. The original trial was scheduled to start on March 6th. Now a new competency hearing is going to take place on March 6th, and the trial tentatively scheduled for May 15th. So bummer on that. A little bit of a delay. And with that out of the way, we got our first super chat done. And Nicola Maxwell, all the way from Scotland, says, "I never hold back when I declare my love for Stephen. My Gosney Appreciation Society is going strong. We love the Gos here." All right. There we go. And we got a lot of ground here to cover in the next little bit. Poor Jeff. Taylor knows that Jeff is covering this trial and is making it as hard as possible for him. What else? we do what we can. But all right, what we're gonna do here as we get into this, I just got home, like literally walked in the door. I had this amazing Spanish dinner with a friend of mine. He and I were having a wonderful dinner, having a bottle of wine. And I just walked in the door a few minutes before we got on here, so I didn't have time to groom the stash. And there's a curly hair that's just bothering me right there. When we get to the video portion, I might just have to pop out real quick and put a little bit of stash wax on it. All right. That's just my personal problem that you don't need to hear about. But just so you know, if I keep doing this, it's ticklish AF right here. Is it weird if I hold my finger like this the entire night? Because that's okay. Just right when I let it go, it curled right up and it hits me right there in the corner. Enough of that. Again, you don't care. Oh, and we're off to a start. We're off to a big start here. We've got 2 more super chats that just flowed in. Well, one of them is a semi super chat. Every month that you're a member, if you want to join the members, right down there, you get a special member chat. And unfortunately, I don't see it unless I happen to be looking at the screen at the exact time it goes by. And it was AA Ron, who also, AA Ron, you sent a chat, the super chat, the instant we signed off last night. And it was gone before I read it. I did acknowledge it. I apologize. I didn't get to read it. And I didn't have time to memorize it. It just flipped on as we were getting off. So I apologize for that yesterday. Bent Halos and Broken Wings, AA Ron, member for 3 months. Thank you for being such a high-level supporter. Bring him back to discuss the case. Of course, I told Gaz everybody's going to want him on. So that's just a given. So the 20th, 21st, 22nd, 23rd, sometime around there next week, we'll have him on. And Alan, who is back from vacation, our mod Alan, who was gone for a month for a vacation in an undisclosed location on planet Earth, has just gifted 5 Legal Vices memberships. So if you were lucky enough to get one of his memberships, please give him a big thank you. Thank you, Alan. You're an amazing gentleman. Deeply, deeply appreciated. Okay. So, as we were saying, what we're going to do here, we're going to talk about the case. We're going to read the arrest report for this particular person. Then we're going to read the police information that is the counts, the charges against him, what he's charged with. Then we're going to take a very, very brief look at this score sheet they have to where they determine the recommended punishment according to this point system for your prior records and et cetera, et cetera. And then we'll look at the sentence he was given. So spoiler alert, he was convicted. If he hadn't been convicted, still 3 days left. Okay, that's right. Alan's coming back on Friday, I believe. Sorry, Alan. I jumped the gun. Enjoy the last few days of your vacation. Yeah. We'll talk about the sentence. So if he hadn't been convicted, well, Gosney wouldn't have been representing him. So he's convicted, but we'll look at the conviction. Then we'll watch the video of the appellate court arguments made by defense attorney Stephen N. Gosney and the prosecutors. And then we'll read the judgment in the appellate case. That's the roadmap. We're going to try to get it all done here by 11:30 so that we can all go over to Good Logic Joe and watch another slog through the Murdoch trial mud pit. But we got an interesting witness with the guy whose job was apparently to feed the dogs, spray out the kennels, and roll up the hose in a very precise manner. Hey, Ron, you don't have to send me a super chat again telling me what the super chat I didn't read was yesterday. I feel sorry for that, but my super chat yesterday was asking if you were going to cover the story of the Titanic 2. Last I heard, the Titanic 2 was a no-go. It's dead in the water, so to speak. As I heard, I could be wrong. That was the last thing I heard a while ago, was they're no longer building the Titanic 2. I could be wrong. If I'm wrong, then we'll talk about it. All right, so let's start. We need to start here. Start at the very beginning. I've heard that's a very good place to start. At least that's what Julie Andrews has told me. And again, we've got two dogs in here, so all the licking, snorting, heavy breathing, snoring, whatever. Dogs, not me. All right, folks, the 444 of you that are here now, I appreciate you being here. Let's get into Stephen N. Gosney out for justice. How is that for dramatics? All right. This is the arrest report for a gentleman named Kevin Patrick Kelly Jr., to be precise. He was born in 1983. So what does that make him? 93, 03, 13, 20, 40 years old this October. So a youngish guy, not middle-aged. And this arrest occurred on February 1st, 2020. So just about 3 years ago, 2 weeks ago. All right. Well, let's see what Officer or Deputy Joshua Mullins had to say about this. This is the arrest report they file out when they throw you in the clink, and then they sit down and they do the paperwork. This is what the prosecution essentially uses to decide how to proceed. They go, ooh, it reports there's a lot of bad things in here. Let's charge him with doing something bad. And this is the basis for that. So, submitted by Joshua Mullins, blah, blah, blah. He did while being this is the person. Mr. Kelly, let's call him Mr. Kelly. Mr. Kelly did while being responsible for the welfare of the victim. The victim. There's a victim in this crime, apparently. He did while being responsible for the welfare of the victim, date of birth, a child under the age of 18 years. Put yourself in the mind of the prosecutor. Here is a man there's a child under 18, a minor child, who is a victim of something going wrong. The victim, a child under the age of 18 years, He did willfully or by culpable negligence. So he did it willfully or culpable negligence. And we'll be talking about that standard, which is usually, he knows it's wrong and he did it anyway, or he did not care whatsoever about whether it was right or wrong. Didn't care about the results of the action. Whether willfully or by culpable negligence, he negligented the victim. And by the way, the worst police reports in the world are filled out by police. The police are horrible at writing reports. So by culpable negligence, neglect the victim. How did he neglect the victim? He neglected the victim, a child, mind you, by failing or omitting to provide him with the care, supervision, and services necessary to maintain his physical and mental health. To wit, cop talk for, in other words, the defendant walked down the center line of a roadway with the victim for a distance of approximately 200 yards without having any care for motor vehicles, in violation of Florida Statute 827.032D. So, criminally negligent for walking down the center of a roadway with a child for 200 yards. He did lawfully endanger the safety of another or their property while intoxicated. So he's walking with a child down the road while intoxicated. Or did, while intoxicated or drinking an alcoholic beverage in a public place, cause a public disturbance in violation of Florida statute number 856.0111. On February 1, 2020, at approximately 16:34 hours. So that's the gist of it. The gist is he's drunk, walking down the street for 200 yards with a minor child in the middle of the street, not caring about all the traffic that's whizzing around him. That's the impression you've got. Well, that's the impression this cop wants to give you. So let's look at the details of what happened. What follows is the details to back up those two paragraphs. So at approximately 16:34 hours, that's 4:34 in the afternoon, I was dispatched to 217 North Apopka Avenue in Inverness. And for Nicola, that's not Inverness, Scotland. That's Inverness, Florida. In reference to an urgent well-being check. There's an urgent check for well-being. Well, who made this? Who made this urgent call for a well-being check? Upon my arrival, I made contact with off-duty Sergeant Dalton, an off-duty police officer. An off-duty sergeant made this urgent well-being check call. I made contact with off-duty Sergeant Dalton, who was with the defendant, Mr. Kelly, and the juvenile victim at Liberty Park. Sergeant Dalton stated that he observed the defendant and the juvenile victim riding a small plastic scooter down the center line of North Apopka Avenue from the intersection of Dampier Street for an approximate distance of 200 yards. Sergeant Dalton, who was with the defendant, Mr. Kevin Kelly, and the juvenile victim at Liberty Park, Sergeant Dalton stated that he observed, I already read that, and I read it again because I just looked down to click on the super chat. Sergeant Dalton was in his personal vehicle following the defendant. So the cop who called this in, the off-duty cop who called this in to the on-duty officers, was following him down the road. And he was following the defendant, who appeared intoxicated due to him walking unbalanced and not upright with a staggered pace. Sergeant Dalton then honked his horn due to the defendant not knowing that there was traffic behind him. And ask yourself, what constitutes traffic? Is one car traffic? Is four cars traffic? Or is it some other number that constitutes traffic? Just questions to ask. And this is one thing, when you're reading police reports, when you're reading criminal complaints from prosecutors, when you're reading these things, even when you're reading stuff from defense, ask yourself, what does that mean? What does traffic mean? What does appeared intoxicated mean? What does unbalanced mean, really? Ask those difficult questions. So he honked his horn due to the defendant not knowing there was traffic behind him. At that time, the defendant then picked up the victim and got off the roadway. Okay, a guy who's walking down the street, appears to be drunk, with his child on a little scooter, walking down the middle of the street. Someone comes up behind him, honks his horn, he goes, aha, picks up the kid, goes off to the side of the street. Okay. The defendant was then observed by Sergeant Dalton to walk into the play area of the park where the victim began to play. The defendant was seen staggering and leaning on objects. Upon exiting the park with the victim, another concerned parent/witness made contact with the defendant in an attempt to prevent him from leaving. The defendant started to become verbally aggressive with the witness and attempted to push by the witness. Okay, you're trying to leave a park with your child, and some person comes and tries to stop you from leaving the park and actually trying to physically prevent you from leaving. And you get upset. I don't know, justified or not, we'll have to see. So the defendant started to become verbally aggressive with the witness and attempted to push by the witness. Sergeant Dalton then made contact, separating the two parties to prevent any physical altercations. This is the on-duty officer showing up, writing the report. I then made contact with the defendant, and I smelled a strong odor of alcohol coming from him as he talked. While standing, the defendant could not keep his balance and swayed during the questioning. While questioning the defendant, he admitted to drinking alcohol throughout the day. The defendant also admitted to walking with the juvenile victim down the middle of the roadway. I then made contact with the juvenile, who was wearing a pair of shorts. No shirt, socks, or shoes were present. I did observe a knot above the juvenile's right eye, and also a cut on the juvenile's toe, which was bleeding. The defendant did not know about the injuries of the victim. The weather at the time was sunny, partly cloudy, with the outside temperatures approximately 59 degrees. I made contact with the witness, who stated he observed the defendant and the victim enter the play area of the park. While inside, he observed the defendant stagger around and also used the walls to support himself. Upon the defendant attempting to leave the park with the victim, the witness stopped them in an attempt to keep them there while another parent called 911. The defendant then became verbally aggressive towards the witness. The defendant was then handcuffed, double-locked behind his back, secured in the rear of my patrol car, and transported to the Citrus County Detention Facility for booking and processing. The defendant was charged. These are the charges. Now, mind you, these are the charges for walking down the center of the street with a child, not wearing a shirt, socks, or shoes on a sunny day, 59 degrees, walking down the center of the street in a scooter. Cop honks the horn. He staggers off to the corner. He's drunk. There's no question he's drunk. He's drunk, but he walks off the side of the street and he goes to the park to play and tries to go home. Well, he is charged with 1 count of child neglect without causing great bodily harm. A $2,000 bond is imposed. And 1 count of disorderly intoxication with a $500 bond. The defendant's total bond was set at $2,500 per the bond schedule. Those are the facts as stated in the arrest report. Now, there's 2 ways of looking at this. One way is this. Hey, is there anything wrong with having a few drinks, getting drunk, and you're taking care of a child? If you can look at it that way. Okay, he just had a few drinks. It's Florida. It's not a busy town. It's a small town. There's a park 200 meters away. He walks down the center of the street like so many of us have probably done in small towns throughout the country, throughout the world. You don't hear the car coming up behind you. They honk. You go, oh crap, I better go over off to the side of the road, which he does. He doesn't fall down in front of the cop car. He doesn't turn around and start fighting the cop. He goes, oh, and he walks off to the side. He goes to the park, hangs around. The kid plays a little bit. He decides it's time to go home. And the neighbors come and they detain him. And they're saying he's getting angry because he's being detained by a bunch of strangers. And they call the police and he's charged. That's one way of looking at it. The other way of looking at it is this despicable human being who's in charge of the welfare of a child gets liquored up and without any regard whatsoever for the safety, either intentionally or with wanton disregard for the consequences, walks down the middle of the highway, totally oblivious to any traffic that's there. He's staggering drunk down the streets. He's into the park. The child is bleeding from a cut in his toe. He's staggering around the park, not caring what happens to the child, not watching the child. And then he starts to get in a fight with people who are trying to detain him for the safety of the child. And so therefore he is justifiably arrested and charged with these things. Those are two ways of looking at this. Which way do you look at it? Are you somewhere in the middle? But that was the initial report filed by the police. Well, let's see how the prosecution looks at this. Let's look at the information sheet that they give. What are they looking at as prosecutors? What are they submitting to justify the charges? Flux asks, when did it become illegal to be drunk? Well, see, there's the thing. Is it illegal to be drunk? Is it illegal to be drunk and driving? Is it illegal to be drunk in your house? Is it illegal to be drunk outside your house? These are all questions you need to be asking. So those are important questions. Baldo Gagger 4000, hey, long time no see. Welcome. My granddad, WW2 vet, would always walk down the middle of the road. He said it was because it was easier to see if anyone was coming after you. Well, that's one argument. Squizgar 2322 says, hey, you said duty. All right. Thank you for that. All right. Fast groups. There we go. Fast group. Steve shall henceforth be known as Stephen N. Gonzarelli, aka Gonzi, aka the Gons. Fair enough. I've just been calling him the Gauze, but we can call him the Gons. All right. Eva Torres, what are we talking about here? Rich, no way it's looking, Steve. No, the way it's looking, Steve may be representing this guy. Which guy are we talking about? Are we talking about this guy we're talking about? If we're talking about it, it's because, was the drunk Gosney? No, of course not. Gosney is representing this guy as Eva Torres thinks may be the case. All right. Well, that's where we are. Now, here we have the prosecution. This is what the prosecution puts in their information. Let's embiggen this as much as we can. And see, look at this wording here. Dang it. There we go. Damn it. I hate these stupid edit windows. This is the thing that at least for me, one of the first things that really, really kind of made me go, the constant reference to the child as a victim. Again, Scory asked a good question. How drunk is drunk? I mean, public intoxication is a thing. Yes, it is. So, but this constant use of the word victim. What is a victim? Oh, and thank you, Rose, for putting up Stephen N. Gosney's. Damn it! I even forgot his book. His book's in the other room. I'll have to go fetch his book here in a bit. But Stephen Gosney, go to stevegosney.com and you'll learn a lot about this fine gentleman. He's a musician. He's a rumble tuber. He's got his job. He also writes a book called, well, we'll grift his book here in just a little bit once we start the video portion of our show. It's Ideas and Answers in Law by Stephen N. Gosney, by the way. All right, here we go. This is the information. Victim is a child. Again, what is a victim? Was there a victim? Maybe this child was a victim to you. Maybe it wasn't. But what is your definition of a victim? The state of Kelly versus the state of Kelly. The state of Florida versus Kevin Patrick Kelly Jr. In the name and by the authority of the state of Florida, Brad King, state attorney of the 5th Judicial Circuit of the state of Florida, in and for Citrus County, prosecuting for the state of Florida by and through the undersigned assistant state attorney in the said county under oath. Information makes that Kevin Patrick Kelly, 1983, in the county of Citrus, in the state of Florida, on or about the first day of February, in the year of our Lord 2020. Now that we got that out of the way, let's look at the specific counts he was charged with. What you know about the facts and what you know about the charges against him. Kevin Patrick Kelly did, while being responsible for the welfare of blank, date of birth blank, a child under the age of 18 years, willfully and by culpable negligence, neglected by failing or omitting to provide him with care, supervision, and services necessary to maintain his physical and mental health, to wit, supervision or care, in violation of Florida statute. So count one is a third-degree felony. A third-degree felony, child neglect, for failing to provide the child with supervision, care, or services to maintain the child's physical or mental health. Basically, that's third-degree felony child endangerment. Count two, disorderly intoxication. And the state attorney did upon her oath aforesaid further information makes that Kevin Patrick Kelly in the county of Citrus, in the state of blah, 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 in the year of our Lord 2020, in the county and state of aforesaid, did unlawfully endanger the safety of another or their property while intoxicated. He did unlawfully endanger the safety of another while intoxicated, or did while intoxicated or drinking alcoholic beverages in a public place cause a public disturbance. So either endangered someone in public or created a public disturbance. Contrary to the form of statute, blah, blah, blah. Those are the two charges. So personally appeared before me, sworn off, stamped, done, everything notarized, everything's taken care of. Those are the two charges that he's being charged with and prosecuted for. Third-degree felony child neglect. And second-degree misdemeanor disorderly intoxication. For being drunk, walking down the middle of the street with a child on a scooter with no shirt, no shoes, in 59-degree weather, going to a park, staggering around a little bit, and trying to leave to go home. Depending how you look at it, it could very well rise to the level of child neglect. It may not. Well, how does this go down? Well, when they look at possible sentences, they look at, I guess in Florida, they look at this score sheet. And when Gos comes on, we can have him talk a little bit more about this score sheet, because this is wild. For basically every bad thing you've done and every allegation that's been made against you, the state assigns a certain number of points or parts of a point. So, boop. Now we're just gonna blow through this really quickly because I don't think it really matters that much. So, offense level 6, he gets 36 points for being charged with a third-degree felony. Apparently, so he gets 36 points. How do we get 36 points? Well, yeah, this is for a level 3, you get between 3 and 16 points, and then all this other stuff happens. It's offense level 6. So there you go. 36 points for a level 6, offense level 6. 36 points right off the bat. And he's going to trial. You can see up here in the corner, he's going to trial. Disorderly intoxication. That additional charge gets him 0.2 points. He's up to 36.2 points right now. Then, is there victim injury? No. So no points for victim injury. Prior record, he's got a bit of a prior record. Now, it's interesting that prior bad acts, prior crimes are generally not allowed to be used against you during trial to show that you likely committed the crime you're currently charged with. But they can sure as shit and are used against you in sentencing. So he's got a few things: aggravated assault with a deadly weapon, burglary, goes down the list. He's got some prior bad acts. That total 59.6 points. No prior serious felonies. So he comes down to 59.6. Total sentence points, 59.6. Now, here we go. This is where we start to get good. He's convicted. He's found guilty by a jury of his peers at trial. They apply this matrix here, this point system, to determine what his sentence should be. What's his sentence? Well, you look down here. If the total sentence points are greater than 44, 59.6 is greater than 44, so minus 28 equals 31.6 times 0.75 equals 23.7. So the lowest he's been convicted. The minimum sentence he can possibly get is 23.7 months in jail, 2 years in jail. That's the minimum sentence he's going to get. Not every state does this does this points thing. Some of you are asking. Cole Roberts and Kim Farnham asked, does every state do this? No. This is a new thing for me to see. So he's looking at a minimum of 2 years in jail for doing those things that you heard about in the information and in the arrest document. Well, here we go. This was his sentence. This was his sentence. Remember, he was charged with third-degree felony child neglect and drunken disorderly. Basically, that's what I would call the charges. Found guilty of drinking a bit, staggering down the middle of the street with his son in a scooter, doesn't hear the car behind him. The car behind him honks. He takes the child and goes off to the side of the street, staggers into the park, 200 yards. It was 200 yards, which is, we'll just call it 200 meters for you metric people. It's a little slightly less than 200 meters. So he walks 200 yards, 200 meters down the road, down the middle of the road, into the park, kind of staggers around, goes, ooh, I'm a little bit drunk here. The kid plays for a while, and then he gets ready to go home, and he's stopped from leaving, and they arrest him and charge him with this felony and misdemeanor. He's found guilty at trial. Defendant Kevin Patrick Kelly Jr., the defendant, being personally before this court, accompanied by the defendant's attorney of record, Charity R. Braddock Esquire, and having been adjudicated guilty herein, and the court having given the defendant an opportunity to be heard and to offer factors in mitigation of sentence, and to show cause why the defendant should not be sentenced as provided by law, and no cause being shown. So basically, that's fancy talk for we asked him to give his side of the story. We asked him why he shouldn't be punished, and we couldn't find a reason not to punish him. So here's his punishment. And the court, having on May 12th, 2021, deferred imposition of a sentence until this date. This date is down there. So the defendant is hereby committed to the custody of the Department of Corrections. He is going to start his prison sentence. What is his prison sentence? We know it's a minimum of 2 years. According to this point system, the minimum he's going to get for this is 2 years. What does he get? To be imprisoned for a term of 10 years. He was sentenced to 10 years in prison for doing what he did, for walking down the middle of the street for 200 yards with his child in a scooter to go to the local park. We our responses are no F that, seriously, no effing way, miscarriage of justice, burn it all down, let's start again, say what? Bit over the top. Jesus wept. What the fuck? We've got it all here. Yeah, oh, come on. Yeah, so that's John Quinn says only 10 years, should be more. That's so wrong. The hell is wrong with shaking my head. Justice system be broke. So clearly he wants to appeal this. Yes, it's Florida. Am I right? So he appeals this. And let's see, I don't think there's anything else relevant here yet. Yes, he's the minimum mandatory provisions. He's a habitual felony offender. He's adjudicated a habitual felony offender and has been sentenced to an extended term in accordance with the provisions. Florida statutes, the requisite findings by the court are set forth in a separate order. Yes, he's a habitual felony offender, they say. He's been in jail already 212 days. So roughly 2/3 of a year he's been in jail waiting for this to go through. Scroll. It is further ordered that the composite term of all sentences imposed for the count specified in this order shall run with the following, any active sentence being served. Oh, and by the way, Jeremiah Hutchins, while you're in the middle of saying while you're in the middle of doing that, and while you're being in shock, I forgot to mention one thing. Not only was he sentenced to spend 10 years in prison for walking down the middle of a road for 200 yards intoxicated and promptly got off the road when he realized there was a vehicle behind him, played at the park, didn't harm anybody, the child was fine, etc., etc. Not only was he sentenced 10 years for that, he was also fined $182,000. $10 years and $182,000 fine. Yeah. Yes. Come on now. Excuse me. What? Can't afford kids' clothes. Ouch. What the heck? Yep. Kill me now. Yep. That's effed up, etc., etc., etc. Well, yeah. Excuse me. What for? Basically room and board in prison. Essentially was what that amounts to. We'll talk more about that in a little bit. So what does he do? Well, we'll get to that in just a bit. Right now, I want to welcome all 726 of you that are currently watching this. Now we're getting to the meat of the argument today. And those of you that just joined, make sure you hit like and subscribe. And let's see, we're all caught up on the super chats. That's good. Oof. So he does what any right-thinking person in his position would do. He appeals. And he gets...
He's the best lawyer in Miami.
Well, he's not in Miami, but he may be one of the best appellate lawyers from the he's one of the public defender's office in Florida, assistant public defender, Stephen N. Gosney, who we've seen many times here on my channel, been on Flux's channel, been on Ricada's channel, been on Megan Fox's channel, been on Megan Kelly's channel, Fox. He's a great guy, amazing lawyer. He gets assigned this case. And what we're going to do now is we're going to play something that, as I mentioned at the beginning, something that most people never get to see. An appellate court argument. We watch all of these district court trials. We watch all of these. On YouTube, we do these things. We're watching the Murdoch trial now, or the rapper trial. This is an appellate trial, and it's very, very interesting how these are done. There's no witnesses. Witnesses aren't called. There's no direct examination. There's no cross-examination. What happens is it's all oral arguments, and both parties, the prosecution and the defense. Nicholas Starov, Union Rep Labor, says, let's not have a Viking drink off in Florida. No. That ain't gonna happen. Not in Florida. Oh, excuse me. So the defense, they put in their grounds for appeal. They put in their appellate arguments. The prosecution puts in their response to that, why they think the original judgment should not be overturned, reduced, vacated, thrown out, whatever. And all the supporting evidence, all the supporting documents to support their briefs that put out their arguments. The panel of judges, different states have different numbers of judges on the appellate court, different Supreme Court justices, but the appellate court, the panel of judges, they read all of the arguments from both sides, and they're essentially going in with their own questions. And they have a specific, they know the issues, and it could be argued that they know the legal issues better than the lawyers who actually making the arguments. So they get thoroughly briefed by their clerks. They get as much information as they can. They come in with their questions. And the lawyers, when they go in, and if you search for appellate arguments online, and if you find them, you'll see that essentially, and we talked a little bit about this last Friday, the appellate judges don't really give a crap about what you're going to say. Apparently in Florida, you get 20 minutes to make your appellate arguments. This guy's life, 10 years of his freedom, are resting on 20 minutes of argument in the appellate court. 20 minutes of oral arguments. And during that 10 minutes, and it's not uncommon to see this, the appealing lawyer will get 2 or 3 words out of his mouth, and one of the judges will say, yeah, we've read this. What about this issue? It may be an issue you never thought of. It may be an issue you don't think is relevant at all, but that the appellate judge is interested in personally. And he will question you about that. He or she will question you about that, beat you over the head and shoulders with it, and try to whittle you down. And they bring their own biases, their own political views, their own judicial views into these questioning. And there can be times when you can have a 10, 15, 20-minute oral argument and literally get out maybe one sentence of what you came prepared to argue. And all of the judges will just be rapid fire questioning at you. It's really a wild process. And you can see a lot of lawyers trying not to get angry, trying not to get frustrated, trying to do things to get their point through while the judges are sending these rapid fire questions in on things that the lawyer may think the judge is absolutely crazy for asking, or they may be very insightful, very necessary, laser focused legal questions, asking for details and the lawyer's judgment on minutia, just these tiny, minute particles of legal theory. And Kim Farnham, our newest member, congratulations for joining the Clean and Sober crew. It's so deeply appreciated. Now, this is where we pick up the video portion of our argument. And we're going to go a little bit over time. We'll probably join. When we finish this up, we'll go into Good Logic Joe's Murdoch trial stream. Looks like we're going to be about 15, 20 minutes late for that. Bear with me, though. You can catch up on the Murdoch trial any day. This is really interesting. This is really important. And before we go, we'll get the midstream grift out of the way. The 780 concurrent viewers, 562 likes. Please hit that like button. And as I've said, Steve Gosney said he'll come back on here and he'll talk about this case. He'll answer the questions you want to ask. He'll get more into it if you're interested in it. And so let's let him know if you're interested or not. Hit the like and subscribe button to let Gosney know we want him on, to let Gosney know he rocks, to help Gosney find his K-bar knife that mysteriously turned up missing right around the time of the Idaho State murders, and prove that Steve did it. So that's obviously the joke one of the day. So, and again, he's not going to be here with us. He's not going to join us with it. For all we know, he could be lurking here. If I was him, I'd be lurking. He may be lurking here. He may be watching. We just don't know. So let me bring this up here. And this is appellate court video, which, as I said, you do not normally see. This is a rarity to see. And so it's essentially filmed with potato cam. It's like 480p resolution. And it's mashed up into a 4:3 ratio, but just get by with it. The important part is the audio and the appearance by Stephen N. Gosney, lawyer extraordinaire, as he argues for the appeal of this gentleman who is sentenced to $182,000 fine and 10 years imprisonment. Let's see what Gos has to say. Let's see what the prosecution has to say. Let's see what the justices of the appellate court have to ask, and then ultimately how they rule on this case. All right, we are going to bring up the oral arguments right now. And again, if you go to Steve's umbrella, I don't know where that came from. Go to Steve Gosney's Rumble. I think I was trying to say Rumble and it came out umbrella. Steve Gosney's Rumble channel. He's got lots of these videos up here. So let's stop that screen, bring up this screen. Oral arguments on the Kelly case. Audio's not the best. We'll get it up as high as we can. And here we go.
All right, our second case on the docket this morning is Kevin Patrick Kelly Jr. versus the state of Florida. It's case number 21-1569. Counsel for the appellant, Mr. Gosney.
And here's our man, Steve.
Your Honors. Steve Gosney for Mr. Kelly. And we have I'd like to have 10 and 10 if we could.
Oh,
10 minutes for the original argument, 10 minutes for a rebuttal.
I probably should have asked you that, yeah.
No problem. I know my opponent over here, so I need maximum rebuttal. This case is it's really rather simple. It's whether the state can paint a language cloud of words to make somebody look really bad in front of a jury of parents, and then the parents will sit in judgment and say, that's really a bad parent. That subjective parenting standard versus the facts of this case, which is you have an obviously drunk Mr. Kelly walking down the middle of the street with his 4-year-old stepson on a little push scooter.
Okay, we learn he's 4 years old.
And he's in the middle of the road, and a off-duty cop, it's a 25-mile-per-hour side street next to a...
So now we learn it's a 25-mile-an-hour side street. That wasn't mentioned. A 25-mile-an-hour side street wasn't mentioned in the complaint. For all we know, it could have been the middle of an interstate, which Steve actually makes that argument here in a bit.
Playground. And a off-duty cop comes up, honks his horn. He doesn't hear it the first time, honks a second time, and gets off. And for that, my client gets convicted of felony child neglect.
No, Mr. Kelly's in jail.
To 10 years in prison and a $182,000 fine. So the question is, and the law should be objective. And this subjectively, we can paint pictures, we can paint word clouds that make him look bad. The little child had, he had dirt on his face and he didn't have a shirt on, and he was scooting there. You can paint all those pictures, but the objective question is whether or not a drunk parent in a 25-mile-per-hour road walking his child to the thing, is that felony child neglect
with sidewalks on either side of the road.
That's correct.
See, so it took 2 minutes, exactly 2 minutes for the first interruption by the judge. Oh, no, stand by, spoiler alert. Yeah, and see, that's the idea. That's where the judge is going with this. Well, he had options. There was sidewalks on both sides, so why was he walking down the middle of the street? So that's an issue that the judge is considering. So he'll interrupt the lawyer for the defense or the prosecution and throw out these type of arguments. Well, what about this? What about the sidewalks? And I'll try to not interrupt this as much as I want to.
Correct. That's correct. There's no doubt that my client was drunk, and there's no doubt he was in the middle of the road with his 4-year-old on his little scooter. So those are the facts. Is that sufficient?
At 4:30 in the afternoon.
Right. And it was a bright, sunny day. There was no question about visibility. It was not... And the first thing I think that needs to be considered is, it's like, well, that's bad parenting. But bad parenting is not culpable negligence. And it's simple. It's not, this really isn't even simple negligence. And I pointed that out when I thought about it, because the child wasn't harmed. The only time the child was ever...
You have to have harm. Is harm an element of the crime?
Harm is not an element, but I wanted to point out the fact that...
And that was beautiful. That was a beautiful way. Oftentimes the lawyer will get defensive. I mean, here I am saying that Steve's a great lawyer. I mean, I feel like a fucking idiot for even saying that. But you often, think, well, is this an element? They're like, well, they'll get standoffish with the judge. He's like, no, and keep moving on.
In a general negligence civil tort, there would be no injury here. The only injury is when the child...
We're not in a civil court. We're in a criminal court. Fair
enough. But in culpable negligence, what is required? The requirement is that there is some fear by which this child would have great bodily harm, right? Or death. And the fear is that he's going to get run over by a car. Fair enough. But that fear does not...
I think the fear is that the age of the child is then submitting him or herself to the care of the adult. And the adult in this case recognizes, or maybe doesn't recognize, the fact that there's sidewalks on either side of the street and chooses to march the child down the middle of the road, double yellow lines at 4:30 in the afternoon. And then when approached by a vehicle from behind and the horn is honked, there's no reaction from the adult. Was there a reaction from the child?
That's not in the record.
Okay. So we don't even know if the child at that age was capable of understanding the danger to then get out of the road. Is
We
that
don't
correct?
know that he wasn't.
Well, that's true, but that would be a state burden to put on that evidence if it was. If there was some standard there. I mean, I think that he is the caregiver. It's a 4-year-old child. We can make assumptions from that. I don't think that's problematic. Whether or not
Should we make assumptions about the age of the child and the child's capability, or should there be evidence in the record about the capability of the child when we're trying to evaluate whether or not there was culpable negligence? For example,
Kim Farnham asks, is this normal with judges? With the appellate judges, yes. Actually, these guys are being kinder than I've seen a lot of appellate judges be. They're not interrupting. If you want to see some fascinating stuff, get a hold of some audio tape. Kurt does it occasionally. Audio from the United States Supreme Court. You want to see brutal interruptions. Watch the United States Supreme Court. Well, you can't watch them because they don't video. Listen to the U.S. Supreme Court. Yikes. But yeah, this is very, very common.
Judge Wallace asked a wonderful question. Did the child react when there was a honk? Do we know if the child understands traffic?
said
Do we know
no.
if the child knows that they should be on the sidewalk, or if they see a vehicle, what they should do? Was there any evidence that the state should have put on in their case in chief about the child's capability, or should the jury just make assumptions based upon their experience with children of similar age?
Well, there is no evidence, and it is a state's burden, but I'd also make a note that
Softball
Florida statutes
question.
827.03(1)(e) provides that drivers have an obligation to look out for people with oops, I'm sorry, wrong statute. The driver, there's a statute, and it's cited in the briefs, that requires drivers to be aware of people with certain physical or mental disabilities or children. So the driver, and this is a 25-mile-per-hour side street next to a playground. This is not I-75. It's not a high, and that if you remember, there was some clouding about, well, this road is sometimes trafficked hard, but at this time it was not. And that was one of the points I brought up. It was a minor point, but it's the fact that they're trying to paint the worst possible scenario and image and plant that image in the parents, jurors' minds as to all these terrible possibilities.
Right, but when we're looking at the sufficiency of the evidence and whether or not it goes to the jury, there are some cases, for instance, the case that both parties argued dealing with the child that was descending from the stairs.
Right. Very good. In fact, I think that's the controlling case if I was going to pick one.
And in that case, there was much discussion about the child's capability.
So this is a lot what you see. They're going, okay, these are the cases that control this particular issue. These are what other cases, when similar legal issues have come up, this is how they were decided. And then you compare and contrast. How well does the evidence in that case, how well do the legal issues in that case fit the legal issues in this case? Are they equal? Do they apply to each other? Can you distinguish them? This is what they're doing with this back and forth. And I thought Steve scored a hell of a good knockout point with this, with the other judge who was asking, this justice was asking while he's walking down the middle of the street. And Steve said, well, the controlling case and statute basically says the driver has a duty to be aware of the fact that there may be children in the middle of the road. So there, he places the burden on the driver as well to look out and not just run over people because they happen to be negligently in the street.
Child had climbed and descended these stairs. That child had only fallen once to their knowledge. The child fell on the last stairwell. My question in that case is, there was evidence put on the child's capability when we judged whether or not the adult supervising the child was culpably negligent, what they should have known about that child's capability. my question is, was there similar requirement in this case to get to a jury that the state should have put on evidence of the child's capability?
I'm not sure if that's determinative, whether they should have. If they were required to, they failed to do so.
Perfect answer. Perfect answer. We already know there was no evidence as to whether that child had the mental capability to know it was dangerous to be in the street and to know what it means when a car is honking behind you. And so the case here apparently dealt with a child that fell down some stairs. And the parent, I don't know the full details of this case. I'm just assuming from what we heard. They knew the child's ability going up and down the stairs. They knew what the child was capable of. And the prosecution apparently showed that the parents knew the capabilities. They showed the child's cognitive abilities to be able to do this. Whereas he's saying in this case, there was no evidence. The prosecution didn't put any evidence on here. Whether the child knew it was dangerous to be in the street, whether the child knew that they shouldn't be out in the middle of the street, whether they knew what it meant if a car honked or a car came. The state didn't do that. So the judge is asking, well, does the prosecution have an obligation to prove the child's mental capability or lack thereof? And Steve gave the perfect answer. I don't know for sure if they have a legal obligation or not, but whether or not they do, they didn't make that argument. If they didn't do it, doesn't matter because they didn't do it. If they do have an obligation, well, they didn't fulfill that obligation because they didn't do it. Beautiful answer.
So, I mean, I know that's a little bit of a dodge, but
it's not a dodge. It's a beautiful
answer. The issue in this case is whether or not the simple action, the singular action of walking down a 25-mile-per-hour road, let's just leave it at that, with drunk or not, was that felony culpable criminal child negligence?
I got to ask you about, and you've used this characterization, and it's not false, but you've used this characterization a couple of times as it relates to drunk. I mean, legally drunk is 0.08.
Sure.
This is, well, let me phrase
Falling
it
down
differently.
drunk. I understand. He's drunk.
How do we view that? Because it seems like it's a bit of a spectrum. Because if it's 0.08,
I'm on the alcohol spectrum.
I think you might potentially be criminalizing every suburban birthday party.
Exactly. See, this judge is asking that's a softball question. Steve says, is it felony child neglect to walk down the middle of a street? Forget if you're drunk or not. Is the act of walking down the middle of the street a felony? Well, he's like, well, let's look at drunk. Is drinking at home, is the act itself being drunk criminal negligence? Because if it is, every suburban birthday party is going to be a pile of felonies.
If it is, however, 24 beers somehow disappear in the span of 3 hours.
Yeah, he drank
the guy
24 beers in 3
can't
hours.
stand up. He's trying to fight strangers, and he's got no shoes on. And we look at that phrase supervision. How does that level of drunkenness statutorily bear on that phrase supervision? Can we at least assume that a jury might be able to take that into account as to his ability to supervise 0.08 versus 24 beers in 3 hours?
The Medina case talks about that in that this person is completely not paying attention. So in Medina, that person is not paying attention at all. And I would go back to the Florida statute 316.
Distinguishing this other case where someone wasn't even paying attention,
which requires drivers to pay attention to falling down drunk people in these residential areas or for children.
And now he goes, yeah, this other case is distinguishable. That guy wasn't paying attention. This guy got off the street. And plus, the statute requires drivers to be aware of and look out for falling down drunk people and children in the road.
So drivers, is it culpably negligent criminal for him to drunkenly rely on drivers' good judgment?
Would you at least acknowledge, though, that it's baked into the statute in the sense that the level of ability to supervise based on drunkenness or indifference is a factor that could theoretically be weighed?
I'm not certain about that, because are we criminalizing parenting while drunk? That's not the statute. I mean, it's not a felony to be falling down drunk with a child in the house. And there's case law to support that.
Perfect.
So would it
Perfect
be
answer.
then your contention that that's not something that a trier of fact should consider at all? in a
Well,
negligence of
there's a
child
totality.
case?
I would say that there is a totality of the circumstances consideration. So, the question, and that's why I want to eliminate these things about he's shirtless and he's got dirt on his face or whatever, he doesn't have shoes on, because those are just facts to paint my client as a bad parent, right? But bad parenting is not the felony. Same thing with falling down drunk and being a parent is not a felony.
I want to try to separate your issue 2 from your issue 1, because I understand that you're making systemic arguments about the validity of the statute. So let's set that aside to the extent, and I'm not asking you to concede your second issue, but let's set it aside for a second to the extent that we can, and just ask about the statute as it's written and talk about that word supervise. How can the faculties of the supervisor not be a factor?
Well, it is a factor in that it's part of the totality of the circumstances. The question, though, when it comes to a singular instance of alleged child neglect, is whether the fear of great bodily harm, death or great bodily harm, it's kind of that's paraphrasing, but the statute is, what is the feared great bodily harm? And that's why the no shirt on is a red herring, because
you're talking about 2 separate things.
Right, but it's similar.
I'm definitely going to talk to your colleague about the no shirt on for the child, because as it relates to the reasonable death or great bodily harm of the child going shirtless at 59 degrees, I don't know if I'm there either. But I'm not talking about the child. I'm talking about your client. And I'm talking about his physical state.
It is part, I think it is a reasonable thing for the trial court
We've
to
got 1,000 concurrent viewers. Thank you, guys. We had 1,000 viewers.
What
Love
I'm
you
saying
guys.
is
Thanks for
these
being
facts as given in the totality of circumstances are not sufficient to find culpable negligence under the case law. So, I don't, the following the level of drunkenness, sure, that's a factor.
So the argument here we're getting to is it negligent to be drunk out walking in the middle of the street with your child? Yes. Is it criminal negligence? Does it rise to the level of culpable? Knowing evidence. Hey, Kurt, welcome. Welcome here, Kurt. We are watching some great Steve Gosney appellate lawyering going on right now. So is it culpably negligent? Is it criminal negligence to be walking down the street? Does it support a finding of 10 years imprisonment and $182,000 fine?
But is that sufficient? I don't think it's sufficient to reach the level of culpable negligence, which is very high. And we are basically, this case is criminalizing drunken parenting or bad parenting. And that's one of the reasons the statutes have such problems that I'm arguing.
And that's his argument. If we allow this, we're criminalizing drunk parenting. We're criminalizing bad parenting. He's saying this does not rise to the level of culpable negligence.
Doing point 2 as an alternative, because if this case is, if it is a felony, then we are criminalizing parenting, and that is subject to, that's overbroad and vague. I'm going to hold on to some of my time here. Thank you.
All right, now he's reserving his time for a rebuttal. Here's the prosecutor.
May it please the court, my name is Chris Davenport, and I represent the state of Florida. First of all, as to the clothing issue, that wasn't to show that the child was in danger. It was to show the lack of supervision.
Oh, bullshit.
So it went to, his culpable.
It's exactly what Steve was saying at the beginning of this. It was a word cloud to make him look like a shitty, horrible parent so bad that a jury would find him guilty of being a negligent parent. He was staggering drunk down the middle of the street for 200 yards. It was 59 degrees and the child had no shirt, a dirty face, a little cut on his toe. He was barefoot. That was designed solely to impassion a jury. That's how the police write their reports. They want to make the guy look like a scumbag so the prosecutor can make people look like scumbags so that this can happen. She knows it. It's a disingenuous argument. The judge also knows it. That's why he's hammering her on it.
Culpable negligence. He was so drunk, he took this kid out without any clothes on, basically, which is wearing a pair of shorts.
All right, TJ, you're the only one that's complained about this. No, it's a 480p thing. This isn't for streaming. This wasn't designed for broadcast. This is just a basic ass bitch court record to preserve evidence. This isn't for, this is, Steve sent this to me to be used. It's just part of a record. This is not for, broadcast quality stuff. So no, this is the best it gets. Here we go. Back into it.
And that's, again, totality of the circumstances. Was that definitive? Of course not, but it's another factor. It's one of the things that alerted the 911 caller. It's one of the things that concerned the guy at the playground. They saw this kid with just shorts on. It immediately put their ankles up. Gee, he's not being supervised. So did that make it, dangerous of great physical injury? No, but it goes to his judgment and it goes to his lack of supervision. So that's what the clothing was about.
If there is no evidence of intoxication, have you met your burden?
I think that would be a harder case because I think a reasonable adult who has a kid on a scooter in the middle of the road would be able to protect the kid. If we had all the same facts and the truck came up behind him and neither one of them responded and the truck honked his horn and he kept walking and the truck had to tell him a second time to get off the road and there's cars coming in both directions.
Did he tell him a second time or just honk the horn a second time?
I think the fact that he was staggering drunk showed that he couldn't supervise the child at all versus, if it was a capable person walking the child down the road. I think that'd be a closer case.
Excuse me. What do we make of the fact that he was actually supervising the child? In other words, I think your case probably gets stronger if that child is pedaling his Thomas the Tank Engine down the road by himself.
Yes.
And for example, the defendant is passed out on the side of the road. So what do we make
that would
of
be
the fact
noticeably stronger
that if we look at the statutory language and it talks about supervision, that the defendant was actually supervising the child?
Well, he was actually present. I would submit he was not actually supervising the child. He was with the child, but he wasn't supervising the child. Because someone who was
he did
supervising
move him off
the
the road
child
with a car.
in the middle of the road when a truck came up behind him would have moved the child to the sidewalk. Someone who was supervising a child would have moved when the truck honked the first time.
Is his very presence next to the child making the child safer, though, in terms of increasing the visual profile on the road and making it less likely, for example, that the child would be hit first if you're talking about where a bumper is on a truck?
Probably, yeah. I mean, it does certainly made him more visible, yes.
Okay, so there we see strike, whatever it is, maybe I'll give her maybe a strike 2 for the prosecution. Just now admitting that, yeah, okay, it is more supervising if he's standing there. It makes a bigger target for trucks to see and be able to slow down. And while we're here, Baldo Gagger 4000, the audio is better than some broadcasted trials, than most broadcasted trials, I would argue. Thank you so much for the super chat, Baldo.
Does the record indicate that the defendant is behind the child?
It doesn't really say exactly where they were. They just said next to him, but they didn't.
Does the record indicate any time lapse between the first and the second honk?
It was long enough for the officer to become more concerned that he didn't respond right away.
Where is that in evidence?
But I don't think he said like a time frame.
Is it culpable negligence if the child's 7?
I think that's a closer case. But yes, I would say a 7-year-old who's in the middle of the street with a drunk caretaker, I think that would be closer. It probably depends on the maturity of the 7-year-old in that case.
Is that an evidence issue for the state? The state should have put on evidence of the child's maturity or capability at the age of 4.
I think the state put on his age and the mother testified that, of course, they didn't let him play in the middle of the road, that was not their habit. I think they didn't need an expert to say that a 4-year-old lacks the judgment to get out of the street. I mean, we don't let 4-year-olds cross the street by themselves unless.
All right. Totally anecdotal, not evidence allowable in court. I distinctly remember, and I'm 53 years old. I remember 49 years ago. I remember being a 4-year-old, and in my little area, it was like way up in the hills in a little tiny, lightly populated area. I remember being 4 years old and being in the middle of the street and moving when cars came. So, if you If you're 7 years old and you don't know you shouldn't be playing in the street and cars are dangerous, well, you got bigger problems than being a child.
Are remarkably mature.
I remember being in a
and there's no
crib,
evidence
Kurt.
this kid was. So I would say, it's something that the defense could argue. They didn't argue that here. I think maybe the defense could have asked mom, gee, does this kid go out by himself and is he capable of crossing roads and things like that? The defense didn't ask that. As far as the state having a burden to show that, I think by showing that that's not something they did with this child, and the child was 4, and his lack of reaction when the truck came up behind him. I mean, the officer didn't talk about whether or not the child reacted to the honk, but he said, I'm behind him in this big loud truck, and neither one of them reacted. That shows me a kid who's not particularly savvy.
What evidence was there that it was a loud truck?
Huh?
What evidence was it that it was a loud truck?
The
I understand
officer-
that there was a honk, but I mean every
Right,
car
before
every
that.
car, every car can honk.
Every car can honk. The deputy testified that he was surprised the defendant didn't react when he pulled up behind him because he has a loud exhaust on his truck. And if you're outside today, I think you recognize that loud exhausts can be quite a warning that you should get out of the way.
Do we look at, for purposes of our decision on issue 1, do we look at what could have been the conditions on that road or what were the conditions on that?
See, that was part of the problem, that the prosecution were making the argument that road is frequently congested. But according to Steve Gosney, lawyer extraordinaire, it was not congested on that day.
Road.
I think the could have been conditions, again, go to his judgment and his failure to supervise. Because if I have a 4-year-old and I want to take him to walk down the middle of the road for some reason, if I take him to Orange Avenue, even if there's no cars there when I first take him out there, that's a lot different from taking him to this side street on the other side of the court where there's never any cars. So I think that that's, again, part of the totality of the circumstances.
So we look at the testimony that typically a car comes down that road every 2 to 3 minutes on one hand. And then we look at what actually happened in this case, which it sounds like the off-duty officer was the only car on that road during the time. He had no trouble seeing the defendant and the child. In fact, it seems like the testimony was that as soon as he turned onto that road, he saw him. There was never any issue of, in that sense, danger to the child of being run over on that day.
There you go, right there. Playing in traffic, the off-duty cop was the only person on the road at that time and immediately saw him when he turned onto the road. There was literally no danger of this child being run over by the only person on the road at that time. See, I told you, noob, hang tight. Just as I thought, road was empty.
Because of those particular facts. On the other hand, the whole statute, and I think Judge Wallace got to this a little bit.
We'll get to the judgment here in a few minutes.
Isn't couched as what did happen. It's couched as what could have happened.
Right.
I confess to you that I'm having a lot of trouble reconciling those two ideas in terms of resolving issue 1, and wondered if you might give a little bit of direction or help.
That's a judge very politely saying, ma'am, you're losing this case. You've got about 10 more minutes, 15 minutes to convince me why I should not rule against you. And for those of you that are just joining us here, we got 1,158 of you, 812 likes, by the way. Those of you that are here, the Murdoch trial is starting in about 10 minutes. Bear with me. We're going to be finished about 20 minutes late, and then we'll go dump over into Good Logic Joe's stream. So hang by about 10, 15, 20 minutes late. We'll go over there. I swear to God, you're not going to miss anything in the first 15 minutes of that trial.
I think if he was in the middle of I-4 and there was no traffic at that time, and somebody was parked in the median and saw the child and the dad walking down I-4, I think that would still be culpably negligent, because even though there was no traffic at the time, he's exposing him to a reasonable possibility. All it would take is one car and the kid is going to be.
But there
in a lot of
wasn't
trouble.
one car.
What about
But-
your example of a neighborhood, though, where it's lightly trafficked? Or let's just put it out in western Kansas where you can see to the horizon and there's a big dust cloud that comes up every time that somebody's coming at you. What if that one car is going 100 miles an hour?
I think that would be harder to prove our case. But let me add here that the off-duty deputy wasn't the only car. He was the first car, but he wasn't the only car. He saw him right away, and he even testified. I wasn't that concerned. I think he assumed they were crossing the road, so they were jaywalking. Is jaywalking culpably negligence? I think that's a harder sell.
Why? Why is it
But by
harder
the
to-
time he honked the horn the second time, there were 3 or 4 cars behind him and cars coming from the other direction. So we don't have a situation where there's no traffic on the road at the time. Both of those things are the same here. It's reasonably dangerous, objectively and subjectively. There were a bunch of cars there. The off-duty deputy with his big truck with the loud exhaust was holding those cars back. And I
If
think
I'm wrong, but I think what the record is that certainly the child was in no danger of the cars behind. Or certainly there's no record evidence that the child was in danger of the cars behind. I think the off-duty officer's testimony was that they were piling up behind him.
they were piling up behind him. He was protecting the child. The off-duty deputy was supervising that child better than the defendant was
Was he
because he was
really, though?
protecting him by putting his truck in front of him.
And I think that his testimony further was that by the time he honked the horn a second time, that there might have been a car coming in the opposite direction, but I don't think we have anything other than that.
Right, but there were 3 or 4 cars behind him that he was holding back. He was blocking the road with his truck essentially. And then there were
Was he
cars coming
blocking?
from the other direction. That's when he got concerned why he honked the car horn the second time to try and get the guy out of the road before things got really, really dangerous.
Let me ask you about the instrumentality in terms of the car. I mean, I think what the state's argument has to be is that the child was in reasonable danger of death or great bodily harm of being hit by a car.
Yes,
Where it's not getting hypothermia or
Right.
falling down at the playground. All right.
Right.
So if we're talking about the car, I was looking at the Arnold case. You know, it was the trailer with the knife exposed on the table. And in
Right.
that particular case, the Arnold court said that just the possibility of the child being cut by the knife isn't going to get you there. So
There has to be an actual risk of danger, great bodily harm.
in
Guns
what
don't
sense
shoot
do we
people.
talk about just the fact that it's cars? How do we weigh that?
well, first of all, I would say in the Wynn case, the kid was left on the side of the road, 4-year-old, busier street, no supervision versus a drunk supervisor, which I would submit would be about the same level of supervision.
Oh, bullshit.
And they said that's
mean,
reasonably dangerous.
no.
He could get hit by a car. If I had a knife if he was in the middle of a knife throwing contest, I think the argument in Arnold would have been a lot different. And I think if we would have been in a parking lot with a bunch of parked cars that could start up at any time, that would be more analogous to Arnold than what we have here. And I would say this one's closer to Wynn.
What
Because
about
we're on a street.
What about a unsecured loaded gun?
An unsecured what? I'm sorry.
Unsecured loaded gun. So I'm trying to put you between an operative car and a knife. Maybe I'm trying to put you outside of an operative car. But just a situation in which any parent in the state of Florida has a loaded gun in, say, a nightstand. And the worst thing that you can possibly imagine with a kid happens and they get a hold of the gun and they shoot and kill themselves or shoot and gravely bodily injure themselves. Crime under the statute always?
I would say that would be up to the jury, and the jury's verdict of guilt would be supported by the record unless kind of depends on where the gun would be. If it's in a low drawer next to the kids' playthings, I think that would be different from on a high shelf with a 12-year-old versus in a drawer with a 2-year-old.
Did you say though that it's always a jury issue?
I would say it would most likely be a jury issue. Yeah. I mean, look, if they had it unlocked in a shelf over the stove and the 12-year-old got a ladder and went up there, I think that would be a tough argument for us to make.
Ms. Davenport, I assume that you're proceeding, or you proceeded in the trial court as far as the child neglect with, it talks about care, supervision, services to maintain the child's physical health. It appears to me, I don't think it's a stretch to say you were proceeding under the supervision aspect of that. Is that correct?
Yes.
Okay, so where in this fact scenario, I mean, all the facts that we have here, what was the moment that the state met the threshold burden to prove that there was a lack of supervision?
I would
Good
say
question.
when the off-duty officer turned on that street, there was a car there. It was him. He was careful, thank God. I would say right then, when he's in the middle of the street with a car on it and he doesn't take any action to get out of the road.
So you're saying that that
Ooh.
threshold occurred immediately prior to the off-duty officer honking his horn?
Ooh.
I would say yes, that was enough right there. But we have more than that. So if that wasn't enough, we do have more.
Okay, and I guess my concern is where does the relevance of the alcohol come in order for the state to prove the threshold?
Well, they saw him stumbling on the road before they got behind him. Then the 911 caller
So?
said the guy fell down and it took him a while to get up.
So,
And then this car got behind him and honked. So this was all in the same time frame.
but it was
He
all when the road was
stumbling around
empty.
out there at the time. I think
He was stumbling around
again,
when the road was ass
intoxication
empty.
adds to it, makes it a stronger case for us. The fact that traffic was backing up makes it a stronger case for us. The fact that the cars were coming from the other direction makes it a stronger case for us. But as far as, if we had stopped all the testimony, I think we had enough as soon as he was in the road with the traffic and didn't get out of there when the loud truck got behind him,
And for those of you joining late, Surfing Bird, 911 caller is evidence. The 911 caller, the guy in the truck that was blocking, allegedly protecting the child because the drunken father allegedly was an off-duty police officer. He called the on-duty officers, and then they went to the park, and a couple other people called 911 too. So she's just about getting done here with her case. Her case is going to be coming to an end here in just a few minutes. I think about 4 minutes. And then Gosney's going to step in for the last 10 minutes and finish up his case. Then we're going to read the appellate court's judgment and see how all of this turned out. And then we'll wrap it up and go to Joe. So it'll be about 15, 20 minutes late for Joe, but hang tight. You're not going to miss a damn thing. Stay here with this. Stay here with us. Hit the like and subscribe.
react to the loud
I have to
truck.
challenge that in a sense, though, and I think that that's a really good question, because if the intoxication doesn't factor into it at all, what if he was having a medical crisis?
I think that then you wouldn't have been acting in a culpable, negligent manner. You have
Right.
to have some kind of
Right, so you have to
gross-
you have
well,
to have
that's
the
true. Yeah, if
drunkenness,
he was
right?
just, or if
Ooh.
he, yeah,
There, oh, see, she's made a glaring admission right there. She says the alcohol wasn't really the factor. As Pre-Flex says, it's instead of a 9:30 start, it's a 10:30 start. My understanding was they were going to be doing motions for the first hour. The jury was coming in an hour later. I didn't think the court was starting an hour late. But anyway, stick here. So yeah, the prosecution, the state has just made an admission. The alcohol part doesn't really figure into it. Well, what if he was having a medical issue? Well, then he wouldn't have been culpable. Oh, so it does. The alcohol does figure into this somehow. Surfing Bird, $5. Thank you for the answer. Hey, that's what I'm here for, to answer questiones. Thank you very much. So yeah, let's listen to this admission. The judge going, oh, but if he's having a medical condition, well, then he's not culpable. Oh, so he has to be culpable. The alcohol must factor into it. And then she kind of goes, yeah, oh, crap.
Challenge that in a sense, though, and I think that that's a really good question, because if the intoxication doesn't factor into it at all, what if he was having a medical crisis?
I think that then you wouldn't have been acting in a culpable, negligent manner. You have
Right.
to have some kind of
Right, so you have
gross.
to you have
Well,
to have
that's
the
true. Yeah, if
drunkenness,
he was
right?
just,
Yipes.
or if he had a seizure and fell, that would have been
Yeah,
different. Yeah,
I think you have to have the drunkenness.
You're right with that. That's
And,
true.
and it also seems, going back to my questions to your colleague, that you've got to have an appropriate level of drunkenness. Because if you're 0.08, again, in my somewhat facetious children's birthday party example, you have to have a certain level of intoxication in conjunction with going down the road.
Absolutely. If he had just had the smell of alcohol on his breath, but he was supervising that kid and just made a dumb decision, that's a lot different from stumbling, drunk, I can't talk coherently.
Is it?
Which is what
Is
we
it
had
really?
here.
So going back then
So,
to Judge
yeah.
Wallace's question, when is the moment that the state met its prima facie burden to show a lack of supervision?
Chicken.
That's a hard question because, I'm always thinking
the
about the next
question,
case. Well, no, I don't think so.
On issue one,
because-
it is, right? Because if you didn't
No.
meet your prima facie burden, then it's a reversal.
Well,
Listen to
Judge
that
Wallace's
again.
question.
that's a lot different from
Listen to
stumbling,
that.
drunk, I can't talk coherently, which is what we had here.
So going back then
So,
to Judge
yeah.
Wallace's question, when is the moment that the state met its prima facie burden to show a lack of supervision?
That's a hard question because, I'm always thinking
the
about the next
question,
case.
right?
Yeah. So when he had this he had to be culpably negligent at some point. And she says, the judge asked, at what point in this whole, from the time he left his front door, walked down the street 200 yards, staggering around with his child, listening to the honking horns and getting off the street, going to the playground and trying to come back home. In this array of behaviors, at what exact point was he culpably negligent? And she said, that's a difficult question. And the judge says, no, that is the question. You have to prove the moment that he was culpably negligent, or we overturn the case. That was a strong argument.
That's a lot different from stumbling, drunk, I can't talk coherently, which is what we had here.
So going back then
So,
to Judge
yeah.
Wallace's question, when is the moment that the state met its prima facie burden to show a lack of supervision?
That's a hard question because, I'm always thinking
the
about the next
question,
case. Well, no, I
200
don't think
meters.
so.
On issue one,
because-
it is, right? Because if you didn't
No.
meet your prima facie burden, then it's a reversal.
Well, we certainly met it by the time we have the second honk, traffic backing up, and the guy can't get the kid off the road without falling down. I think we met it right there for sure. What's the earliest time, I think, is a trickier question. We certainly met it here because there's all this stuff afterwards.
So you're
that
kind of
added
making
to
your
the
last
totality of the
stand. You're
circumstances.
kind of making your last stand at the second honk.
I'm saying it's a totality of the circumstances question. And if you want to cut out some of the circumstances, how much do you cut out and we still win is a harder question. We certainly win with the totality of what we have here, where he's stumbling down drunk, doesn't react to traffic behind him, traffic's piling up. And let me just reiterate, this deputy called this a main thoroughfare. This is not a side street.
There were no freaking
It's a
cars
Saturday
on it.
afternoon, so it's not as busy as rush hour, but this is a main street that there were cars on. It has a low speed limit, but we all know that that's not definitive as far as how fast cars are going.
Well, that's the
It
driver's
is a main
problem,
thoroughfare
not the
that he
walker's
chose to
problem.
put the child on. And, in the next case down the line, we have a guy who actually is supervising the child and just makes the dumb decision
real quick.
to walk for 200 yards on a main thoroughfare. I think it's closer without the intoxication, but I think we would still win that. But, again, totality of the circumstances. So it would depend on the age of the kid, it would depend on the traffic at the time, it would depend on a lot of factors. All of those factors weigh in our favor here. I mean, there's a 4-year-old and a really, really drunk parent.
I want to take you back to the supervision question, the Salmons case, the woman in the bar.
Uh-huh.
The reversal in that case was predicated on the fact that even though she was drinking at the time, even though she'd had the one beer and was working on the second, that this wasn't criminal behavior because she was in fact supervising the child.
Right.
It seems like she came out and met the officer who may have been looking in. So it seems like her eyes were on the child. And again, I go back to the fact that this guy was walking next to the child. You made the response, and I think it might be a good one, that he couldn't supervise because he was so drunk. Is that something, though, that was outside the record? In other words, are you saying that we should just say, and who knows, maybe the guy had a super high tolerance and that he was able to supervise better than anybody else in this courtroom would have been after knocking back 24 beers in 3 hours? Is that something that should have been part of the state's burden to show that, hey, even though the guy was literally standing there walking next to the guy, maybe not straight, maybe not upright or whatever, but he was in fact supervising at the time?
Was he supervising well? Was he supervising? Is that the question? Jenny Cake says Steve is great. Yes, he is. And in just about 2 minutes, we're going to get more of Steve and Gosney.
I think that's an argument for the jury to decide whether or not he was supervising in a way that satisfied the requirements of the statute. He was not, checking on the kid and had a beer. He was stumbling down the middle of the road. I think it's different to have a kid sitting in a car with the windows open, happy, than a kid riding a 4-year-old riding down the middle of the road with traffic piling up in both directions.
Piling up
I think those are very different
behind and maybe one car ahead, he said? Maybe one car?
The intoxication was certainly a part of the case and certainly a factor to show that he was acting in a culpably negligent manner by taking that kid out when he was in that state, when he couldn't supervise the kid. If he was at home and the kid was in a playpen, I don't think we could meet our burden here. He chose to take that kid out down the road, down to the park, and not walk on the sidewalk, put him in the middle of the road on this little scooter. I mean, he made a lot of willful choices there when he was in a state that he couldn't properly supervise a 4-year-old.
But similar to the case with the mother in the bar, there's a barrier between the mother and the child, and that barrier is space, and it's going to take the mother a longer time to respond to any emergency that may arise.
Right.
Here, there's a barrier. And
Gosney's coming up very, very shortly.
He's physically there, and it's going to take him 2 honks instead of 1 to respond. What do you make of that analogy?
I think that's a great analogy. I think that that's very true, that his state of inebriation did render a barrier there. I think the mother in the bar was probably negligent. But culpably negligent is a higher standard. And the jury, by the way, was told about that standard. The state didn't argue, he's just a bad parent, throw him in jail. The jury was given explicit instructions on this and what the standard is and what the state had to prove. So, I think that's a very good analogy, that it did render the supervision worse.
Any other questions?
Thank you. If there are no questions, thank you.
All right, now, for those of you that are still here, we've got 1,028 people. Some of you have already left to go to the Murdaugh trial. Hang tight. I swear we'll be there in 10 minutes, 15 minutes tops. We'll be at the Alec Murdaugh trial. Now we're going to get to the final presentation, the rebuttal from Stephen N. Gosney. We'll quickly read the judgment. Then we'll go over to Good Logic, Joe's channel, and watch the Murdaugh trial. So hang with me, just bear with me here for about another 15 minutes tops. You're not going to want to miss this argument and see how it turns out.
We have a little bit more than 8 minutes left, counsel.
Awesome.
Awesome.
The fact is about the gun example that was brought up it was that if there was a loaded gun and it was unsupervised. Well, that case, I would analogize that with the Parrish case, in which you have a father who's being held at gunpoint. The child runs out, 5-year-old child runs out, holds on, says, "Daddy, don't shoot my daddy." And the cop's there at a gunpoint. He puts his gun down. He says, "Order your kid away," because, and the parent says, "No, I'm not going to do that." Kid holds on to him, and there's that interaction. Well, and that was not culpably negligent. Now, why was that not culpable? Because he can rely on that officer to not shoot his child. Same thing that our client can rely on section 316.013015, which says every driver shall exercise due care to avoid colliding with pedestrians and exercise proper precaution upon observing any child or obviously confused or incapacitated person. So that Parrish case goes to the gun example, and it's not culpable negligence. As far as the playground, again, we're getting a little bit of...
So brilliant argument there. That's a brilliant argument, and it's a perfectly reasonable argument. You're not culpably negligent for having a gun around a cop who's pointing a gun at you because you presume the cop is not, you have a reasonable belief the cop is not just going to start shooting you. The same way if you're in the middle of a street, you have a reasonable assumption that the cars are doing their duty, their due diligence, their duty of care to not run you over.
Of a bad parenting word cloud.
Yeah,
well,
Darryl
this road
Brooks.
is heavily trafficked and all there's just piling up and all that. No, it was Saturday. It was 25 miles per hour. That's a playground. That's a residential playground. The reason it's 25 is because there's children there. And it's a side street. It's not the main road.
I think your colleague pointed out that there was record evidence testimony that this was in fact a main thoroughfare. And if I look at the Wynn case, which is our other road case where the child was unsupervised wandering around the exit ramp of I-275, we don't know what that record was, but the exit ramp of I-275 certainly leaps off the page.
Right.
In terms of how you view it as I-275. Well, by definition, that's an interstate. It's an exit ramp. You know, people are coming off at highway speeds. What do we make as it relates to making this a jury question of that testimony that this is, quote, a main thoroughfare, close quote?
Right. Well, again, this is part of the totality of the circumstances. If you read the Wynn case, the facts of that was a parent who intentionally abandoned their child in this high traffic.
I'm just asking you about main thoroughfare. I'm asking you about that testimony in this case.
Well, it's a word description to make the client look bad. The fact is, it's 25 miles per hour. The fact is, it's in front of a playground. The fact is, it was a bright, sunny Saturday, 4 o'clock. It was no visibility questions.
Are those conflicts in the evidence, though? If you have, in terms of making it a closing argument, if you have one side saying, and you heard the off-duty officer say that this is a main thoroughfare, and the defense counsel stands up and says, well, he can call it an expressway all he wants, but there's a playground there. It's cars every 2 to 3 minutes. It's a 25-mile-an-hour speed limit. And you'll decide, ladies and gentlemen of the jury, how busy this road was. Do you understand my question?
Right. Well, and there's an error that they allowed that external testimony as opposed to what actually was the fact, and that was in point 6.
Well, calling it a main thoroughfare doesn't mean that, I think that's separate from your 5th point on appeal. I'm just asking, calling it a main thoroughfare, does that create the jury issue?
I hope not. I hope not. I mean, when I think about 25 mile per hour main thoroughfare in front of a playground, I think of Beach Street along the river here, which I drive home every day.
Isn't it a community-based sort of decision, though? Like, what might be a main thoroughfare in downtown Daytona Beach might be differently classified than a main thoroughfare in Inverness. But
it goes to the facts of this case in that, I mean, well, you were talking about Wynn, and the Wynn case is that the child gets abandoned. He goes crying. The guy slams the door, runs off, leaves the guy there. The kid goes chasing after him, crying on a major highway. Now, there's a difference. When you're driving, you exercise a different duty of care on Beach Street here than you do going on to I-4. It's just you don't expect children to be in that area, whereas there's playgrounds and you have a low speed limit, and that you have school zone that gives you extra duties of care in addition to the statutory duty of care. So I think I missed the question though. What was the
main thoroughfare? I think you got it to the best of your ability. I'm just really struggling with the idea that you have a bunch of jurors in Citrus County who might be the ultimate arbiter over what is or isn't a main thoroughfare. Well, but if we look at Wynn and assume effectively correctly that I-275 is a main thoroughfare, right. That again, it leaps off the page. Maybe this isn't something that you take away from the jury. Maybe it's a question of fact based on people who are in that particular community who can make that.
But that goes back to when I first opened. We're going to paint a word cloud bad picture, and this is a bad parent, and you're going to give it to 6 jurors and say, is this guy a bad parent or not? We're going to condemn him.
And I'm not fighting with you, but I'm also not word clouding. I'm using 2 words.
Well, main thoroughfare. Yeah. If it's a main thoroughfare, does that mean he's guilty? I mean, I think.
Does that mean it's a jury issue is my question, not that he's guilty. This falls under Medina, Salmons Parish, Arnold. It is not Wynn, because Wynn is, we understand the difference between a high-speed and also the actions, the intent of the actions. A guy that just abandoned it. My guy's standing right next to him the whole time, so he doesn't hear it. We don't know if it was he.
And that's a brilliant strategy right there. The judge continued to ask the prosecution Well, but what he was standing right there. He was with the child. He was supervising the child. He was right there. He was blocking the child from the vehicles behind him, wasn't he? The justice kept bringing that up. So Steve is reflecting that. He's using reflective listening to his advantage. He's using the same words that the judge was using a minute ago, saying, well, he wasn't fleeing. He was standing right there with the child. Brilliant, brilliant persuasive argument tactic, the reflective listening going on there.
Deaf? I mean, is somebody deaf supervising the kid? Are they negligent because they're crossing the road? I mean, how much is this criminalizing just a parent who didn't hear a honking horn? And the guy gets 10 years in prison? It's crazy. And let me just go back to the abandonment. He was standing next to him the whole time. And that was uncontested. At the second honk, he moves him out. He moves him to the side. So, you know, he doesn't hear the first honk. I mean, my Subaru doesn't have a very strong honk. Now, I know that it's like, well, it's a truck, we think air horn. This case is criminalizing a parent who is drunk, and that's not criminal. I mean, it's not a crime to be drunk and he's supervising his kid, albeit to a deficient standard, but it's not culpably negligent standard based on the case law. Let me see. I really think that statute that on the duty of drivers is important also, especially given the low speed limit and situation. Let me see.
And while he's looking for that, Flux says, I'm angry you're rushing us through the Gosney for Murdoch. Gay.
No? Okay. Hey, well, thank you very much for your attention and your time. And my client begs for some relief here because the disproportionate nature of the sentence, and I think I argue this equitably, is unbelievable. And I mean, personally, I have to deal with this case. Thank you, Your Honors.
Thank you very much both for your presentation. It's a really interesting case, well argued and well briefed, and just enjoyed hearing from you both today. And we'll be in recess.
Okay, now we've got that out of the way. It's done. How did the appellate court judges decide this matter? First, let's take a little bit of a break here. Lenka Story says, this is interesting. I like this. Legal Vices. How do I find more videos like this? Two ways. Steve Gosney, you can go to his Rumble channel, which totally slips my mind right now. He's also setting up a brand new website, StephenGosney.com. Go there. Some of these may be there, or you can go to YouTube and search for Stephen N. Gosney. There's a few cases there. Also, if you're just interested in the idea of appellate judgments generally, appellate court arguments generally, you can search for appellate court arguments, and there'll be some courts that do put their videos online. So those are a couple of the ways. And Notes on a Phone says, quick random cue, Jeff. If a defendant attacked you like Schabusiness attacked their lawyer, what would you do? Probably laugh. That was a pretty weak attempt. Like I said, we're going to talk about that tomorrow or Friday. Lame. Okay, so here we are. What has Stephen N. Gosney asked for? His client, for doing what we just talked about. His client was sentenced for walking 200 meters, 200 yards down the middle of a road where there was no cars initially, and eventually there were 3 cars behind him and maybe 1 in front of him. And he was honked at twice before he moved it off to the side of the road. For that, he was sentenced to 10 years imprisonment and fined $182,000. What did Stephen N. Gosney, defense lawyer extraordinaire, ask? What did he ask for? He said, just give me something for relief. Mitigate this out. This punishment is way over the top for what he did. You just make the sentence reasonable, Your Honor. Don't send this guy to 10 years. Don't fine him $182,000. Make it reasonable. Gosney asked for this to be made reasonable. So let's look at what happened. Sentenced 10 years, $182,000 fine. Gosney says, Judge, the punishment far outweighs any reasonableness. you please just give him some relief. Did he get any relief? If so, what relief did he get? Exactly. The punishment doesn't fit the crime. What punishment would fit the crime? 10 years was bullshit plus an unthinkable amount of fines. Yeah, okay. 10 years is ridiculous. Should have been 20. Sarcasm. So that's it. Let's bring this up. Let's bring up the judgment. There was a whole long list of facts and applicable arguments. We don't need to get into all of those. We're just going to get into the judgment side of things. Let me shut these down so we can embiggen it. Get to the analysis of the legal arguments. What we're going to find out here is, did Stephen N. Gosney get any relief for his client? Was there any change in the 10-year, $182,000 fine? And if so, what was the change? We conclude the state did not present legally sufficient evidence. Hang on here. I've got some overlapping windows. Here we go. And we need to get this. All right. How's that? Can we all read that? Let me get rid of this. Right, get rid of that. All right. We conclude that the state did not present legally sufficient evidence to sustain the charge in this case because it did not establish that Kelly acted with culpable negligence. Rather, it submitted evidence illustrating simple negligence or an incomplete regard for the child's care. This does not satisfy the state's burden. To put it mildly, Kelly's actions as the child's caregiver left much to be desired. But he did not show an utter disregard for the child's safety. Although Kelly was severely intoxicated, he never left the child's side. And when an off-duty officer honked a second time, Kelly helped the child onto the sidewalk. Thus, his actions did not indicate an entire lack of care. Kelly's mere physical presence guaranteed the child was not pushing his scooter down a road unattended. It also increased the child's visual profile and acted as a possible barrier between the child and the vehicle. It's what the one justice kept talking about. We acknowledge that the off-duty officer described the road as a main thoroughfare. The state contends that given this description, a jury should have resolved whether Kelly's actions rose to the level of culpable negligence. But this contention elevates the off-duty officer's description of the road above the actual evidence presented to it. So the off-duty officer that called it in said it was its main thoroughfare, but the prosecution did not present any evidence that it was actually a main thoroughfare. The officer's description of the road elevates it above the actual evidence presented about it on the day of the incident. The state's witness testified. This is the cop. State's witness testified that with the exception of weekday rush hour, the road was lightly trafficked. On the Saturday afternoon in question, the off-duty police officer was initially the only car on the road with Kelly and the child. He had no trouble seeing either of them immediately and from over 100 yards away. Throughout the course of the entire incident, 3 cars backed up behind the officer, and no car passed in the opposite lane. The road speed limit was 25 miles per hour, but no evidence or inference showed a car going even that quickly. Kelly was able to exit the road directly to a safe place. So here's the results. Here's what happened. Did Stephen N. Gosney get any relief? And if so, what was it? We do not foreclose the possibility that a caregiver could show utter disregard for the child's safety simply by accompanying them down the middle of a dangerous road. This, however, is not Kelly's situation, and Kelly's conduct, while negligent and deeply irresponsible, did not rise to the egregious level of conduct necessary to show culpable negligence. This is his relief. The next sentence. For this reason, we reverse and remand, directing the trial to vacate the conviction and dismiss the case. Steve Gosney asked to just make the punishment fit the crime. The judge said no crime was committed. Send it down to the trial court. Tell them to enter in a judgment vacating that conviction. Steve got the guy completely off. The end. Complete reversal. Completely got the case thrown out. Masterful, masterful appeal. That is lawyer extraordinaire Stephen N. Gosney. So boom, he just says, hey, 10 years and $182,000 is way too much punishment to fit that crime. Give him some relief. The relief he got was the conviction vacated and thrown out. That's our Stephen N. Gosney. That's where that noggin gets him. So there you go. Huge win for Stephen N. Gosney. All right, the 959 of you that are here still right now, make sure you hit that. We have 300 more likes than we have actual votes, 350 more likes than we actually have likes. I mean, votes. So hit that like button, hit the subscribe button on your way out. And what we're going to do now is we're going to do a little bit of grifting for me, a little bit of grifting for Steve. And then I'm setting us up right now to dump into Good Logic's channel. Let me get that set up right now, and then we'll wrap it up. We'll go to Good Logic. We'll stomach another day of this amazingly interesting Murdoch trial. All right, redirect. Boom. Good Logic, Joe. Save. Saved by the logic. All right, boom. So what's going to happen when I end the stream here in just a couple of minutes, it's going to automatically feed us over to Good Logic Joe. If it doesn't, the little box is going to come up at the top of chat saying, do you want to go over there and see what's happening? If that doesn't work, just go to Good Logic's channel and go on the live video. All right, let's wrap this up. The poll, the like poll, hit the like and subscribe to Let Gosney Know We Want Him On. 38% of you said that. 20% of you said Let Gosney Know He Rocks. That's a total of 58%. And the rest of you said, help Gosney find his K-bar knife and prove that Steve did it. Okay. So there we go. That's the end of the poll. Thank you for being there. How long did he sit in jail before the appeal? I'm not sure, but it was at least a year. We can ask Steve that when he comes on next week. Because we're going to have him back next week. And the dogs are playing around with a toy in the background. Cool. All right. So thank you so much for that. I just don't know for sure. And you guys, little doggies are playing tug of war while we watch. And we got to scroll back up a little bit to get the other last of the super chats. And then we'll wrap this bad boy up with a little bit of grift for Mr. Stephen N. Gosney. The Kenosha Kid said, so the road was more traffic than Eliza Blue. Yep. Okay. Oh, dear. Okay, everybody. Thank you for being here. But before you go, Stephen N. Gosney, well, SteveGosney.com, StephenGosney.com. Go there or go to crimelaw.net, one of those two places, and you can order your own copy of Ideas and Answers in Law by Stephen N. Gosney that looks at legal issues and ideas and solutions to problems. For example, the burden of proof, concealed carry of a firearm in a vehicle without a permit, is simple touching battery, BB guns, deadly weapons, police narration of a video, citizen's guide to police interactions, a beginning framework for originalism, appellate chances of success. And that's the interesting thing here. It's actually the title of one of his chapters. The appellate chance of success is at best 6 in 1,000. So basically a 0.06% chance of winning an appeal. And he slam dunked this. So if you want to go order your own copy of Stephen N. Gosney's book, Ideas and Answers in Law, go to the two websites, SteveGosney.com or crimelaw.net, and order it with a foreword by attorney Andrew F. Branca and a blurb on the back saying, a compendium of scholarly level criminal analysis. You would be hard pressed to find a better source to write a book on criminal law by Nick Rekieta. Great guy. Steve will be on here next week at some point. We'll work it out with his schedule to find a time where he can answer your questions about this trial. So there we go. Thank you guys for being here. I love Steve. I consider him a very, very close, dear friend. And I watched this. I thought this was amazing, and I wanted to share this with you. I got his blessing to do it. And so we had our first, could there be more instances of Stephen Gosney out for justice? Chat, you're the best chat ever. Thank you for being here. Mods, you did a fantastic job. Thank you. Chat, everybody, take care. We'll see you on the flip side over at Joe Logic, and join us tomorrow when Chandler will be here for OJ's Thursday stream. It'll be our Thursday OJ with Chandler, our newest guest. Take care. See you over at Good Logic. Ooh, I don't want to end it there. I want to end it over here. Bye now.